For more, we're joined by Salah Hassan's attorney, Bahar Azmi. He is the legal director of the Center for Constitutional Rights, lead counsel for the plaintiffs in the Abu Ghraib lawsuit. Bahar Azmi, thank you so much for being with us. Explain this lawsuit that you have.
In 2004, after military investigative reports revealed the role of private military contractors in the atrocities in Abu Ghraib, we actually, with other lawyers, brought 3 lawsuits against 2 sets of private military contractors. One on behalf of 256 victims, which was dismissed by a court of appeals in Washington. A second one against a company called L3 Services that provided translation services to the U.S. military, and that was brought in Maryland, and that settled on behalf of 71. And this last lawsuit on behalf of Salah and 3 other victims of torture at the Abu Ghraib hard site against a private military contractor called CACI International, CACI, which provided interrogation services for the U.S. government. And the allegations there, which are based on our own investigation and conclusions of military investigators, is that CACI employees played an essential role in the torture and abuse in Abu Ghraib by ordering low-level military employees to soften up detainees for eventual interrogation by CACI employees. So this lawsuit seeks to hold CACI, the corporate entity, responsible for the actions of its employees.
I wanted to turn to the Ghraib case. In 2012, the Supreme Court heard oral arguments on whether corporations can be sued in U.S. courts for human rights abuses committed overseas. That case is called Ghraib versus Royal Dutch Petroleum. We spoke to Marco Simons, legal director of Earth Rights International, who explained the case's significance.
Yeah, so this case is really about whether a corporation that participates in serious human rights abuses, such as crimes against humanity or genocide or state-sponsored torture, can profit from those abuses and shield those profits from the victims when the victims come to take them to court. It's essentially about whether corporations are immune from any kind of liability for serious human rights abuses worldwide. And that's what the Court of Appeals held in this case. They said under no circumstances can a corporation ever be sued for the most serious human rights violations today.
That's Marco Simons talking about Ghraib versus Royal Dutch Petroleum. Simons is legal director of Earth Rights. Can you talk about the significance of this case?
Yeah, so Ghraib appeared to present the possibility that corporations would be immune for liability under this alien tort statute. But the court pivoted a little bit and instead limited the alien tort statute in a different way by suggesting that when all of the aspects of the legal claim occur abroad, extraterritorially, courts should not hear those cases. In Ghraib, we had Nigerian plaintiffs, British and Dutch corporations, who alleged that there were crimes against humanity and torture committed in Nigeria, so there were no connections to the United States. And in our case, the district court nevertheless dismissed our case on a kind of narrow, a formalistic reading of the Ghraib decision. But our position in the Court of Appeals, which recently heard our appeal, is that the Supreme Court recognized that when there are connections to the United States, such as here where you have a U.S. corporation who entered into contract with the U.S. government and conspired with U.S. military personnel in a U.S.-run prison, the connections to the United States are so strong that U.S. courts have to provide a remedy to foreign nationals for international law violations.